Jeff McShann told ABC that this office had known since April that the drugs had been destroyed.
And he's the spokesman for the DA's office.
That is right.
The media relations.
That is correct. So I was entertaining plea negotiations with the felony chief of the 184th on a dopeless dope case.
Emily, you used to be a prosecutor.
That's right.
I mean, when you hear all this going on, you get the list of the destruction, you find out that they've known about it, that the office, at least in some capacity, has known about the destruction of this evidence. What's the first thing that goes through your mind?
I can't say it on TV, but it's an O expletive. As a number 3 prosecutor, I understand that they have a lot of cases. I understand that dope cases aren't the highest priority. I understand that they're overworked. But to represent that you're ready to go to trial and not having made sure that the evidence is actually available, I don't want to fault the prosecutor for this. I just think that she probably was overworked.
So let me ask you this, and for our viewers too. In a dope case, is it enough for there to be an allegation and maybe an independent witness that there was drugs? And does the prosecution or does the government have to go to the next level and actually present that evidence in court for them to actually gain a conviction? Right.
Well, the answer to that would be yes, because it's called chain of custody. They have to mark the evidence, tag the evidence, transport it to the whatever agency it is, and when it's checked out to be tested, it has to be checked out. When it's checked back in, it has to be checked in. And you can't introduce a lab report unless you're able to tie what it is that they tested. So although they did have a lab report that purported to be methamphetamine, they couldn't make it relevant in the criminal trial without also producing the drugs.